two calls. First call, what's the likely outcome of Ben's action? And as soon as I see that, I'm glancing at the paragraph above it just to tell myself what the action is. It says Ben has commenced an action against Polly, seeking declaratory relief that the farm is burdened by his easement. Okay, so call one is asking, in essence, is Ben going to prevail in getting his easement to continue to exist? Call two, what's the likely outcome of Polly's A, claim of breach of contract, and B, claim of breach of the covenant under the warranty deed? So it sounds like there's going to be a land sales contract here that winds up being merged into a warranty deed. So just from the calls, I'm guessing that easements and sale of the property and survival of the easement is a big issue, and the entire doctrine of merger in conveyancing is a big issue. Okay, so start with the top. Al owned a farm. In 1990, Al deeded an easement for a road along the north side of the farm to his neighbor Ben. Ben immediately graded and paved a road on the easement, but did not record the deed at that time. Al and Ben both used the road on a daily basis. The easement decreased the fair market value of the farm by $5,000.
It's happened many, many times on the California bar exam. They're a little bit more explicit here than they have been in the past, where they give you the precise information that the easement decreases the fair market value of the farm by $5,000. But the question always is the easement valid? So if you've studied past hypotheticals, this one should have been really easy, or should be really easy for you.
And without reading any further, a lot of those facts go to notice, and so I'm sort of waiting to see if the property is sold and there's a bona fide purchaser for value, so that I can argue that they had notice. That may happen here, it may not, but paved a road, both used it, those would fit with notice. So in 2009, Al deeded the farm to his daughter Carol, and she recorded the deed.
All right, so again, the issue of the failure to record here. Ben failed to record. I know he's going to record in 2011, I see that, but he failed to record in 2009. So now there's a question: does Carol's recordation in 2009 extinguish that easement? And the answer is going to be no. The thing is, Carol is not a bona fide purchaser for value without notice. Number one, she didn't pay valuable consideration, which is one of her elements of BFP. And point number two, she's aware of the easement. Therefore, Carol is not a BFP. Our rule is transfer of the serving estate subjects the new owner to the easement unless sold to a BFP without notice. As indicated, she's not a BFP without notice. Therefore, the easement survives, and then we see in 2011 Ben records his deed. That's a good recordation of that deed, and Ben holds that easement. And by the way, he's providing record notice to subsequent BFPs.
So then in 2012, Carol executed a written contract to sell the farm to Polly for $100,000. The contract stated in part, "Seller shall covenant against encumbrances with no exceptions." During an inspection of the farm, Polly had observed Ben traveling on the road along the north side of the farm, but said nothing.
We can see here Polly's not going to be a BFP. She's aware of she has actual knowledge of this easement. So therefore, she's not a BFP. And also she has unclean hands, because she's supposed to inform Carol at this particular point that she's seen Ben traveling. She keeps her mouth shut in that regard. The unclean hands I don't think was a big issue, but Polly certainly does have unclean hands here.
So under the land sales contract, Carol has covenanted against encumbrances. So Polly might have some rights under the contract. But now in the next paragraph we see in 2013, Carol deeded an easement for water lines along the south side of the farm to Water Company, the local municipal water company. The water lines provided water service to local properties, including the farm. Water Company then recorded the deed. The easement increased the fair market value of the farm by $10,000.
All right, that easement is also in the chain of title. Water Company recorded the deed, and it increases the value of the farm even. So therefore, in a way, you can say Polly's not going to be damaged. However, when it comes to land is considered unique. Maybe she doesn't want that there. In either case, let's go on and see what actually happened.
In 2014, after long delay, Carol executed and delivered to Polly a warranty deed for the farm, and Polly paid Carol $100,000.
Well, I'm sorry, but now under the doctrine of merger, as Dr. Johnson stated, all rights under the contract merge into the deed, and one loses all of the rights in the contract. So therefore, Polly's not going to have any rights under the contract. So the likelihood of her claim of a breach of contract is it's going nowhere.
The deed contains a covenant against all encumbrances except for the easement to Water Company, and no other title covenants. Polly recorded the deed.
Okay, so she has full knowledge. She recorded the deed. She does have rights under the deed, but she has absolutely no rights under the contract. Therefore, we can take care of call 2A, her breach of contract claim. She has no breach of contract claim. The likely outcome is she loses her breach of contract claim.
In 2015, Polly blocked Ben's use of the road and objected to Water Company's construction of the water lines.
Polly had no right to object Ben's use of the road. Ben had an express grant easement to use the road. Polly had not only record notice, but she was on actual notice. She observed Ben. Therefore, she has no right to do this.
Ben has commenced an action against Polly seeking declaratory relief that the farm is burdened by his easement. Polly, in turn, has commenced an action against Carol, seeking damages for breach of contract and breach of the covenant under the warranty deed.
All right, let's just start at call 1. What is the likelihood of Ben's action? And I think I've pretty well indicated to you. But the issues that you'd want to cover here is he has an express grant easement. You want to look at how is the easement created. Express grant, he did record it in 2012. It wasn't extinguished, as we indicated, because there was no sale to a BFP at any time. Therefore, he holds the easement. It's valid. He can defend this in any court of law, and Polly is going to lose. Ben will prevail on that action. We've already indicated on call 2A, there is no claim under breach of contract. However, there is a claim under call 2B, breach of the covenant under the warranty deed. There are 6 covenants under that deed. The bar would want you to go through all 6. As I said, this has all been tested before. There are plenty of past hypotheticals. You go through each one of the 6 warranties under the deed, discuss it one at a time. One of them is a covenant against any encumbrances. There's an encumbrance here. So therefore, there is a breach of this covenant, and there's other breaches you'll find as well. And therefore, Polly is going to prevail under this one.
Against the easement to Ben, not against the Water Company easement, because that's expressly acknowledged in the deed.
Correct.